Hi, this is the Business Guy. The law is changing. Starting January 1st, 2024, if you own a U.S. corporation or LLC, you're going to want to watch this entire video because it will definitely affect you, and you'll want to share this video with everybody that you know who owns a U.S. company. Why is this a big deal? Because every beneficial owner of a U.S. corporation or LLC or the equivalent needs to file a beneficial ownership information (BOI) report with a division of the U.S. Department of Treasury called FinCEN, the Financial Crimes Enforcement Network. And those who intentionally don't do it can get slapped with a $10,000 fine and up to 3 years in prison. Plus, under Title 18, $250,000 to $500,000 for providing false information about it. So the Corporate Transparency Act requires those who own, control, or form most U.S. corporations and LLCs to report identifying information to the government. But fret not, because I'll show you what to do, and if needed, we can help. FinCEN has issued their final rule implementing the law, and I've not only read the entire act word for word, but I've also read the entire set of updated requirements. So I've studied this with a fine-tooth comb, and I'm going to tell you exactly what you need to do. And if you haven't, click subscribe so you'll be up to date when new information comes out. Now, to be clear, this is for U.S. companies only. So when you call us to set up an offshore company, as long as it doesn't do business in the United States, such as an offshore company holding an offshore bank account, this FinCEN reporting requirement is not required for offshore companies. So I'm going to talk about what you need to do as a business owner and as a practitioner. And by the way, we do offer a service where we can file this paperwork for you for a very reasonable cost, so visit assetprotectionplanners.com for more free information. And then in the very end, I'm going to tell you what I uncovered the most shocking thing about this brand new law and how it massively increases, yes, surprisingly enough, increases the privacy of ownership of corporations and LLCs for law-abiding citizens. So who am I to talk about this? I've been the CEO of a legal document firm that files corporations and LLCs for 32 years. So this is my perspective and that of our on-staff attorneys. But don't take this video as legal advice. You can call our office and speak with one of our attorneys or consultants, and we have filed literally millions of pages of documents, most of which are corporations, LLCs, and trusts, both in the US and internationally. So some would say that I would qualify to talk about the subject. So real quick, here are the main updates. First, for existing companies. Existing companies must report starting January 1st, 2024, an ownership report with FinCEN, and you have until January 1st, 2025 to comply. Second, companies formed on or after January 1st, 2024 must file the report within 30 days of company formation. Also, if any of the information on the form was inaccurate when it was filed, the reporting company must file the corrected report within 30 calendar days after becoming aware of the deficiency. Now, if one company owns another company, you go back and report the human being that owns the other one. Okay, now with that backdrop, let's get down to the bottom line. As a business owner or practitioner, what do you have to do? When setting up a company, you must report the beneficial owners to FinCEN. Now, so I don't keep repeating myself, here's how the Act defines a beneficial owner. A beneficial owner is someone who exercises substantial control over a corporation or LLC formed in a U.S. state, or Indian territory for that matter. So control means, say somebody doesn't own the company, but they control it, such as through a contract. Number two, someone who owns 25% or more of the company. And number three, someone who receives substantial economic benefits from its assets. So one or more of those things, control, ownership, or benefits, as stated above, are what the Corporation Transparency Act calls beneficial ownership. Now, when you form a company or are a beneficial owner, you must provide the following four things to FinCEN. Number one, the full name of the reporting company. So ABC Corporation or XYZ LLC. Number two, any trade name or doing business as. Number three, the business street address of the reporting company. Number four, the jurisdiction where it was formed, such as Nevada, Wyoming, Idaho. And number five, the IRS tax ID number. For beneficial owners, you must report one, their full legal name. Number 2, their date of birth. Number 3, a current residential or business street address. Number 4, a non-expired image of a passport, driver's license, or other government-issued ID card. So a photocopy of a driver's license or a photocopy of a passport is fine. No financial information or details about the business purpose or operation are required. Just those 4 things: name, birthdate, address, and ID. Now, if you're an applicant, such as an attorney setting up a company, and are not a beneficial owner of the entity, you not only will have to report all of the beneficial owners, but you'll also need to provide that same information on yourself, the applicant. You can also apply for a FinCEN number. Anyone who asks for it can get one to shortcut the process. Now, first of all, my opinion. Now, there are incredible tax and lawsuit protection benefits for operating your business in a corporation or an LLC. So in spite of the law, operating without a company is not a good option. And frankly, as the CEO of one of the leading firms that forms companies in the US, I'm not particularly happy about this law. I think it's well-meaning, but places an unnecessary additional ongoing layer of paperwork on owners of every company in America. Let's say you have 2 million companies a year and 2,000 of them are bad guys. So 99.9% of the good guys have this extra burden for the 0.1% of the bad guys. Now, do bad guys lie? Of course. And reading through this law, the bad guys simply have to lie about who owns the company and have little side contracts about who receives the benefits, which they're supposed to report to according to this law, but won't because they're lying bad guys. Plus, when filing taxes, the tax filings already report the ownership of the company anyway. So there's no need for the additional reporting requirement simply because of a governmental database inefficiency. Moreover, there are easy and obvious ways around it. First of all, this only applies to US companies, not offshore ones like we talked about before. So one can simply operate using an offshore company. Plus, there are certain kinds of trusts that our in-staff attorneys set up to own real estate and other assets that a corporation or LLC can own, where one can maintain privacy of ownership. For example, we set up land trusts left and right. The land trust can be owned by an LLC, and the owner of that property remains private. So if you're a good, honest business person who simply wants extra privacy, give us a call for more information, and we can help you do that legally. But it is the law, and we're all subject to it, and we have no legal choice but to comply. I don't like going through airport security either. I'm a good guy. I'm not going to hijack any airplanes. But I can lay on the ground and kick and scream and cry, or I can lay my bags on the conveyor belt and walk through the body scanner. Only one way will get me on the plane so I can see my family on the other side of the country. So why the heck did they do this? Here's a little background. The justification for Democratic Congresswoman Carolyn B. Maloney's sponsorship of this bill is that she says nearly 2 million corporations and LLCs are formed in the U.S. every year, and very few states require information about who owns them. And I admit, I must agree, we are by far the largest offshore company formation firm in the nation, see offshorecompany.com. And in order to set them up, we need a reference letter from the person's banker, a reference letter from their CPA or attorney, the company purpose, the source of funds, a notarized copy of a utility bill or other residential address verification, and a notarized copy of a passport. So 6 things. To set up a U.S. company, we just need the name of the first director, and for an LLC, that can be another company as its manager. That's it. No proof of anything. They say that criminals launder money through these companies to buy buildings and other assets, and law enforcement cannot find who owns them. And as somebody who sets up thousands of companies, I don't want the bad guys contacting us to set up their companies. I pound this into our staff on a regular basis. We only want good, clean, honest business. All others we do our best to turn away. So there you go. But don't worry, call us. We have attorneys on staff, and we have a service where we can help you comply with this law, as we said. We also sell forklifts for those of you who have lots of companies. Okay, so let's talk privacy, as I promised. Someone can only get your beneficial ownership information that's been reported to FinCEN in these 3 ways. Number 1, a request by a local tribal, state, or federal law enforcement agency. Number 2, a request made by a federal agency on behalf of a law enforcement agency of another country, and each must prove to FinCEN they really do have the right to it. Number 3, a request made by a financial institution with customer consent. So unless you're a bad guy, you really have nothing to worry about. I mean, not even a bank can get the information without your consent. Now, you do need to file this information every year, just like you file taxes every year. This is an annual filing. More about privacy later. Bearer shares. The law also outlaws bearer shares. Those are stock certificates made out to the bearer. Whoever holds the stock certificate owns it, so it's not made out to a person's name. That's something we used to offer to clients back in the early 90s when I started in this business. Those are outlawed. Penalties. Okay, now the bad things that can happen to you if you, 1, provide false ownership information or fake ID documents to FinCEN. Number 2, and this is a big one, you willfully fail to provide complete or updated beneficial ownership information. Or number 3, you receive a subpoena and you knowingly disclose its existence or other requests for beneficial ownership information unless doing so is needed to fulfill the request or the enforcement agency authorizes it. If you do any of those 3 things, provide fake info, willfully fail to provide the info, or blabber about a subpoena for the info, you can be subject to a civil penalty for $10,000 and under Title 18, which is up to $250,000 for individuals and $500,000 for organizations. Oh yeah, plus up to 3 years in prison. So don't do that. It also adds that if you're just negligent, saying you didn't know that you had to do these things, you're not going to get into trouble, and the Secretary of the Treasury can waive the penalty if it was due to reasonable cause and not willful neglect. Okay, so let's talk more about privacy. And here's one of the amazingly good things. Now, when I read this provision, I almost hit the floor. This, I think, is a good thing for privacy advocates. I don't know of any other laws in America, even the privacy laws in Switzerland and the other tax and privacy havens don't have this. And now I'll quote the law: criminal penalty for the misuse or unauthorized disclosure of beneficial ownership information. It says the criminal penalties provided under 5322 shall apply. Title 31 of U.S. Code Section 5322 says you can be fined for not more than $250,000 or imprisoned for not more than 5 years or both. So if I read this right, which I think I did, disclosing the owner of a U.S. corporation or LLC, and you may have to shell out over $250,000 and sit in a clink for 5 years. So they gathered this information from owners, but only agencies such as law enforcement doing investigations can even access it. That means that even someone who's sniffing around, who's trying to sue you, or actually does sue you in civil court, cannot access it. Better for privacy. It clearly states that you can have a nominee, such as a nominee officer or director, in the public records. So your name doesn't need to show up for somebody who might be sniffing around. And this is a service that we do provide to law-abiding citizens who want to protect their assets from prying eyes. So FinCEN will know who the owners are, but that big ugly guy who wants to sue you may not. Beneficial owners don't include minor children, nominees and the like, a mere employee, one who inherited the company, or a creditor of the company, unless the creditor is also a beneficial owner. Offshore companies, again, the law does not apply to offshore companies or LLCs, and we set up tens of thousands of offshore companies for law-abiding citizens, and you can visit us at offshorecompany.com so you can have an offshore company, and this law does not apply. Exempt companies. The full reporting requirement also does not apply to publicly traded companies, financial institutions such as banks, or exempt nonprofits such as churches. Now here's an even more complete list of companies that don't have to report: companies or compacts for governmental use, a depository institution such as a bank or credit union or their holding companies, a broker-dealer exchange, clearing agency or investment, insurance, commodity exchange, public accounting, or public utility firm. It also doesn't apply to churches or nonprofit exempt companies and certain financial market or pooled investment companies. Now here's the big one. If you have more than 20 full-time employees in the U.S., your income taxes show that the company earned $5 million in gross receipts and you have an operating presence and an office in the U.S., you're exempt. Or if the Secretary of the Treasury and the U.S. Attorney General both agree that you should be exempt. But as we said, even if you are exempt from reporting, you still have to file a report as to which particular provision in the code makes you exempt. And the person filing this report must provide the same information that a beneficial owner would have to provide, such as name, address, birth date, and ID. So for all U.S. companies, even companies that are exempt from reporting still have to file a report. So what are the takeaways from this? First of all, every U.S. company needs to file a report to FinCEN, even exempt companies. If you set up a company for others, such as an attorney, you need to report the beneficial owners as well as yourself. This law applies to U.S. companies only, not offshore ones, and not to trusts like the ones we set up. So if you need help fulfilling this legal requirement, don't sweat it. We do have a service where you can hire us to do this for you. Our number is 1-954-400-1050, or you can visit us at assetprotectionplanners.com. And please be sure to click like and subscribe to this channel if you haven't already. Thanks for watching. This is The Business Guy.